All right, so this has come up in my practice a few times recently, so I wanted to make sure I posted a video on it. I want to talk about pour-over wills. What's their purpose? What do they mean? What do they do? So first and foremost, what is a pour-over will? So a pour-over will is a type of last will and testament. So your last will and testament is the document where you state where you want your stuff to go after you pass away. Who gets what? Whether it's a person, a charity, whatever. Who gets your dog even, right? Your personal items. Who gets your money? Now, a pour-over will is a specific type of will that is commonly utilized when someone has a revocable trust or a living trust. We call it a pour-over will because the intention behind this type of will is that your assets are supposed to pour over into your trust. So you have a trust in place. You normally do that, at least if it's a revocable trust for probate avoidance. We want your assets to be distributed to the people who you listed in your trust, so we want them to pour over into your trust. It is a common misconception that having a pour-over will means that all of your assets that were not either retitled into the name of your trust, listed your trust as a beneficiary, or otherwise tied or connected to your trust during your lifetime won't have to go through probate because you have a pour-over will. In fact, this just came up in my practice, which is why I'm talking about it. I'm doing a trust administration right now for someone who thought all the assets of the decedent were in the trust because they had a pour-over will. So anything that the decedent didn't move into the trust during their lifetime or otherwise tied to the trust, well, it should be in the trust, right? Because they have a pour-over will, and that means that everything pours over into the trust. Yes and no. So it's stating the intention that we want everything to be handled as if it's within the trust. However, if the person who creates the trust and the pour-over will and signs it, if they don't actually take the step of moving all of their assets into the trust during their lifetime, or listing the trust as a beneficiary or a payable on death recipient or transfer on death recipient, or assigning the asset to the trust, whatever that particular asset calls for. If you don't do that during your lifetime, then that asset is not within the trust. And all the pour-over will does is it lets the probate court know that it was the intention of the person who created the trust and the will that all their assets would be in the trust. So if something got left out, it was a mistake, they didn't mean it or they forgot about it. And so they want the court to kindly just say, hey, it goes to the trust, which is why we list the beneficiary as the trust, because the trust document explains where it goes further, but we want to the first thing we have to do is actually get the asset into the trust so that it can come under the trust for whatever type of distribution is written in the trust. So if you think that because there's a pour-over will, if someone forgot to put an asset into the trust, it's fine because the pour-over will automatically puts it into the trust, that's not how it works. The asset still has to go through probate. A judge has to be the one who then says, yeah, I can tell by the pour-over will that this person actually did want this asset to be part of their trust. So I'm going to go ahead and issue this order stating it should be part of the trust. But that doesn't happen until they issue the order at the end of probate. So if you want to avoid still having to do a probate, even though you have a revocable trust, which was assumingly set up so that no probate was needed, you do have to be certain that all assets are actually either retitled or transferred into the trust, or again, list the trust as a beneficiary, POD, TOD, or otherwise assigned or tied to the trust. Because if you don't do this, the pour-over will doesn't actually save you from probate. And again, I'm bringing this up because I've had this happen a few times now in my practice where people thought that was the case. It says right here, these assets are meant to be in my probate. And yeah, and it could very well say that. I've even seen it in codicils, which are amendments to wills, or in trust amendments. where there's reference to additional assets or assets that the person wants to be considered in their trust or is giving them away as part of their trust. That's totally fine and it shows their intent. But unless the asset is actually transferred or otherwise tied to the trust during that person's lifetime, if they pass away and that asset's just still in their name and it doesn't list the trust as a beneficiary or it wasn't, in any way tied to the trust, then that asset will have to go through probate. It may eventually make it into the trust, and that is the purpose of the pour-over will, to show, hey, that's what we wanted. But it's so important that during your lifetime, if this is a situation that you're in, that you do make sure that your assets are tied to your trust during your lifetime, because if not, that pour-over will, although it's sort of a catch-all, meaning it shows, hey, I want this stuff in the trust, doesn't automatically put it there. A probate is still required. All right, so I hope this helps and explains sort of what a pour-over will is for and what it does, what it doesn't do. And if there's any other questions about estate planning or estate planning documents or anything at all to do with elder law or probate and you're in Florida, please don't hesitate to contact our office or atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.